it kind of turns the entire analysis on top of its head and how we normally structure our laws.
We're the Armed Attorneys. Today we're talking about a federal judge out of the state of New Jersey, or New Jersey. First of all, just generally, your life has been really hard, and then it got better, and then it got worse again. But guess what? It's getting better again because a federal judge has invalidated much of New Jersey's new carry law. We're going to talk through it, and we're going to talk through what we think will happen next. But before we get started, show your support for the Second Amendment by hitting the like button.
And today we're talking about Judge Renee Bum, who granted a temporary injunction enjoining the state of New Jersey from enforcing multiple parts of its new gun control law. And as a little bit of background to this, New Jersey they had this justifiable need requirement under their licensing scheme. And then we had the New York State Rifle and Pistol Association v. Bruen case, which basically invalidated that for the state of New York, therefore for the entire country. Well, in response to, and what I oftentimes compare this to is, like Gallagher smashing a watermelon, we have all of these states kind of scrambling to put the pieces back together and in many circumstances making gun laws way worse than they were before.
Yes, which is just amazing to me because, we have Bruen, which, Bruen is wonderful. But remember that we have all of this wonderful language out of the Supreme Court. But then we have what really is a pretty narrow holding, which is that May issue permitting schemes are not constitutional, right?
Yeah, and so that was the only controversy before him.
Right, exactly, because that's how opinions work. I mean, you can only decide what's before you, but we've got great language for evaluating the Second Amendment. But so these states that they could have just said, okay, we're just shall issue now. Here we are, and move forward. Instead, what they're doing is enacting these huge gun control schemes that are then before the courts being held invalid and unconstitutional because of the standard put forth in Bruen. So they're really sort of cutting off their nose to spite their face.
Yeah, and that's exactly what New Jersey did in this particular circumstance. December 2022, Phil Murphy signed into some carry restrictions into New Jersey. And we saw the state of New York kind of make the same moves here, but they made lots of sensitive places. They banned carrying functional firearms in vehicles. Whenever you apply for your license, you had to have character references, safety courses, and then, of course, carrying liability insurance, that's one of the first. I know California is trying to do that as well, but they added all these extra hoops.
Right. And so instead of just saying, okay, we have a shall issue state, they put all these restrictions into place, which, of course, were immediately challenged under Bruen. Although the plaintiffs in this case, interestingly, they didn't challenge everything.
Right.
I might have challenged all of it, frankly, just because I don't think you should have to pay money for liability insurance to carry a firearm next to exercise constitutional. That's like saying, armed attorneys, you have to buy insurance for exercising your First Amendment right on the scale, right? I mean, it's silly.
You might hurt somebody's feelings, better get a bond out on that.
Right, exactly. And Lord knows we hurt feelings all the time. So anyway, what we've got is they challenged the vehicle restriction, which, I mean, what's the point of carrying a firearm if you can't have a functional firearm in your vehicle? So there's that. But then they challenged libraries, museums, places that serve alcohol, entertainment facilities, and interestingly, what New Jersey did, which I think New York did, I don't know, I'm trying to remember back, and I think New York did the same thing, basically say, well, all private places are actually off limits unless the owner says they're on limits.
Yeah.
Posts a sign or tells you.
I saw some pictures out of New York with the guns welcome sign, and it was, pretty odd, but it kind of turns the entire analysis on top of its head and how we normally structure our laws. Usually we have the government or we have private individuals tell us what we can't do. You start with the presumption that you're allowed to do something. Yeah. And then the government and private individuals say, you can't do this. Right. This completely flipped it on its head to where it's saying, you can't do this unless we say it's okay.
Exactly.
That's very bizarre.
Totally bizarre. But so Judge Bum, who was appointed by George W. Bush, in case anyone is curious, someone actually got really mad at us one day because we said someone was an Obama appointee. And they were like, that kind of assumptions is what gets everybody in trouble. And then the judge actually was appointed by Obama. And it was like, what now? So we'll say it definitively. This judge was appointed by George W. Bush. She wrote a 60-page opinion. It's so well-reasoned. It's so fantastic. And she lays out really clearly. She's like, look, the government's arguing like, well, this is our intent and this is what keeps us safe. And she's like, look, guys, this isn't what I'm deciding here under Bruen. And she actually, I think it's worth reading. She says, it's not the role of this court to either pass judgment on the costs and benefits of firearms restrictions, right? So I'm not telling you if it's a good restriction or a bad restriction, or to defer to legislative intent, right? The court's role is straightforward. The court must answer two questions. One, does the Second Amendment's plain text cover the challenge provision, right? So is this a restriction on the Second Amendment? And two, does evidence support the restriction, right? Is there a historical analog?
Right.
Right?
The Bruen standard.
Right. So what happens to all of these restrictions, Richard?
Yeah, so she goes in and follows New York State Rifle and Pistol Association v. Bruen to the T. Obviously, this conduct is covered by the Second Amendment. And then looking for those historical analogs, the government came up short. They did not have they had some arguments. They had some interesting arguments, but it wasn't arguments based in the text history or tradition of firearms regulation when it comes to the Second Amendment.
Right. They actually cited a Texas law. Texas restricted firearms in the 1800s. I think it was like 1890.
Okay. Yeah. Post-Civil War.
Yeah. Like places of learning. But even she was like, well, yeah, I mean, this has come up before, but the courts have said, I think Bruen called that law an outlier. So
Yeah.
she's like, why are you bringing this up? But interestingly, she looks at this presumption that New Jersey wants to set that firearms are illegal unless told otherwise. And New Jersey kind of argues, they're like, well, that's not a restriction, right? Because all these private businesses have the absolute right to allow firearms. So that's not a restriction on the Second Amendment. We can do this. And she makes a very well-reasoned argument about like, well, no, because what you're doing is making a rebuttable presumption that firearms are illegal. Essentially, the state is saying firearms are illegal unless we tell you otherwise, which, like Richard said, that's not how criminal law works.
No, and a part of this order as well is that the sensitive places that were enumerated in the law void for vagueness. I mean, there's too many places here and places that aren't clearly defined by law. There's no way that a reasonable average person, and that's what when we talk about void for vagueness, we want to be our average carrier. Do they know what places are on limits and off limits based on the language of the law? She says no.
Right. And that's we call it substantive due process. So we are guaranteed due process under the law. We've got procedural due process, which is kind of what you hear about most of the time. That's your right to access the court system. And for the government has to be put through the paces. You have to let the process play out in order to be deprived of life, liberty, property, et cetera, et cetera. But we've also got this thing called substantive due process, which, essentially we're talking about, were you able to understand the law in order to follow it? And when something's void for vagueness, you've been deprived of substantive due process. So, and my understanding, and of course, the opinion came out very recently. So I believe, if my quick read of the opinion was correct, that the plaintiffs didn't even make the void for vagueness argument. She just found it and was like, look, I mean, in addition to the Second Amendment arguments, this just isn't okay.
No. And what's important to understand also, I mean, we expect the state of New Jersey to appeal this. So if you're in New Jersey and thinking, woo, I can go start carrying in museums, hit the brakes a little bit because
it's currently enjoined.
Right, currently enjoined. But
probably going to be, going.
Yeah, we see the Third Circuit taking this up. I mean,
I'm stepping on Richard. We're giving you bad news, and we're both trying to give you bad news, and I'm just stepping on him. You can keep going.
Yes, but, for the time being, these things take quite some time to play out. So with all of these, we do have quite a few breaking court decisions because all these states are scrambling to, make gun owners' lives more difficult. But you have to hit the pause button, make sure that these orders are final out of the district courts, out of the trial courts, and haven't been enjoined or appealed.
Yeah, and a good example is what just happened yesterday. Again, I know this is way after. So what just happened in New York, which is essentially we have the New York law, which was enjoined by the district court. The Second Circuit said, no, we're not going to enjoin this. New York can enforce their law, and the Supreme Court declined to take that up. So New York gets to enforce their really bad gun laws, even though the district court had enjoined them. Will that happen here too? Maybe. So this is good celebration. But remember that so much can happen that puts a pause on our celebration before these things really play out. So just be very careful before you start carrying.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And always please question and comment for us below. We're talking about this because someone asked about it in the comments. So until next time, we're the Armed Attorneys.